Hi there, I'm Jim Zirin. Welcome back for more conversations. The setting for a trial in our criminal justice system is stern and familiar. The evidence is in, the lawyers make their closing arguments, the judge charges the jury on the law, the jury deliberates, and in most cases returns a verdict of guilty. Then on appeal, the conviction is affirmed. The defendant is carted off to jail, maybe even to death row, but is it over? Often there are lingering questions. Did the defendant really do it? Is he perhaps innocent in fact, the victim of a horrific miscarriage of justice? There is a team of lawyers and investigators who did not forget the convicted. They labor in appropriate cases to establish innocence, largely by scientific DNA testing, where such evidence may be relevant. These are the men and women of the Innocence Project, a nonprofit organization that in its 26-year history has exonerated 362 people in the United States, including 20 who served time on death row, means they were sentenced to death. These people have typically served many years in prison for crimes they did not commit. With us to explain her work is the brilliant advocate Nina Morrison, staff attorney for the Innocence Project and longtime crusader for the innocent wrongfully imprisoned by our justice system. We're pleased to welcome Nina to this table. Nina,
I know.
How long have you been doing this?
I have been at the Innocence Project for 17 years.
17 years. Now, wow, you could be a top partner in a top New York litigation firm making millions of dollars. Why are you doing what you're doing?
Oh, I don't know. I was never very good at making money, and I love what I do. I have a wonderful job, and I come from a public service family, and this was sort of always the path I knew I would be on. I got a scholarship to law school designated for people who wanted to go into public service, so I made a commitment very early that this was the path I was going to take.
And you haven't deviated?
Nope, I have not yet.
Now, our criminal justice system is said to be the envy of the world. How is it that innocent people wind up in jail and wind up on death row? That's not supposed to happen.
It's not, and we know a lot more today than we ever thought possible, thanks in part to DNA evidence, but not entirely through DNA, about how often and how egregiously the system gets it wrong. So far to date, since 1989, there have been 362 people exonerated through DNA evidence after conviction. Some of them were sent to death row, some of them were serving life sentences or long sentences, and there have been thousands more exonerated through other means, witnesses that come forward, alibis that get discovered, other kinds of forensic evidence. And we have seen this happen in staggering numbers, and also in cases, thanks to DNA, where everyone recognizes that a grievous mistake was made. So the question is not just, are there innocent people in prison, but how does this keep happening and what can we do about it?
So are all of your cases exclusively DNA type cases?
Not anymore. When the Innocence Project was founded in 1992, the co-founders Barry Scheck and Peter Neufeld started it as a way to try to use DNA evidence to exonerate people who said they were innocent and were sitting in prison. They had both been public defenders, both had a little bit of a flair for science in the courtroom and an ability to explain it to juries, and were contacted by some lawyers who thought they had an innocent person in prison who had been wrongly convicted in a rape case, had an alibi. He was in a church basement with many family members when the rape occurred, but got convicted based on what appeared to be a misidentification. And they took this case, were able to use DNA to clear this man, and said, wow, this seems like a really powerful tool. If anybody else has a case where they think that DNA evidence could help them, write us a letter. We teach at Cardozo Law School, and by the time I got there in 2002, the letters were spilling out of mail bins in the hallways. We had a staff, small staff just dedicated to trying to screen the cases. And now we take cases in the front door that involve DNA evidence, but we and our colleagues are also starting to take a number of cases that don't involve DNA. I've also had a lot of cases that start off as a DNA case. It might be a rape case or a murder case where we think we can test a knife or test something that was used in the crime, maybe some evidence from the rape. That evidence is either gone or it's destroyed to the point where a test isn't possible. But at that point, if I've been representing the client for 5 years, I've gotten to know them and their family, sometimes along the way, I will discover evidence of their innocence through investigation, sometimes through chance, and we don't want to just leave those people behind, so we will sometimes keep the case open. And the most common route that takes is that we find evidence hidden in the files of police or prosecutors that is very favorable to the convicted person and sometimes actually proves their innocence. An eyewitness statement that was suppressed, alibi information, and when we're able to get access to those files, that can be the key to crack open the case.
Now, in some of your cases, has the defendant pleaded guilty?
Yes, a number.
Why does someone plead
More than
guilty?
10% of the DNA exonerations.
10%?
Yeah,
So
yeah.
why does someone plead guilty to a crime they didn't commit?
So the reasons for that are complicated, but also kind of simple. There is something in the United States, really in many ways unique to the US, called the trial penalty, which is that if you go to trial and lose, the courts often are empowered and do give you a much greater sentence. We're talking many times the sentence than if you take a plea to that charge or to a lesser charge. So someone might be facing, say, an armed robbery count, and they might be facing 15 to 20 years in prison. But the prosecutor says, you know, if you plead to attempted robbery or to possession of stolen property, you know, we're overloaded, the courts are backed up many months, I've got other more serious cases to take to trial, I'll give you 6 months, I'll give you a year. That is a very hard thing to turn down. I mean, imagine I'm a parent of an 11-year-old. If I had a young child and I was facing 10, 20 years in prison, you might miss their whole childhood. Somebody says you can do 6 months and go home. Horrible though that is, at least you know you'll be there when they not just graduate from high school, but even when they enter the next grade. And jail is horrible. I mean, a lot of reasons people plead guilty is the excruciating experience of being in jail for a few days or weeks or months. You lose your job, your kids might go into foster care, you lose your housing sometimes, your spouse may have financial troubles, and unfortunately, we have a two-tiered system in this country where people who can afford to make bail in places that still use cash bail can be out fighting their case, working with their lawyers, making the decision under less traumatic and stressful conditions than someone who's sitting on Rikers Island facing the threat of violence and being separated from their families every day.
So just to back up for a minute,
Yeah.
are most of your cases like murder cases and rape cases where the victim and the defendant were at close quarters, and so perhaps there is DNA evidence that's left at the scene of the crime?
That's right. So most of the cases the Innocence Project takes these days are DNA cases. Typically those do involve some sort of exchange of body fluids, blood at the scene, you know, the kind of thing where biological material comes from the assailant. But DNA is getting increasingly advanced, so we are taking cases where DNA is shed on the handle of a knife, or a person might drop a bandana or a hat at the scene and you can get skin cells from inside that. That is true in robbery cases. I had a client who was exonerated about 8-10 years ago who had been convicted of a carjacking, and the perpetrator and the victim in the parking garage had struggled over a screwdriver that he was wielding, and he had cut himself, got in the car, drove away. In her car, the car was found abandoned a few days later, and there was blood on the driver's side door and a little bit on the dashboard. We tested it, and it turned out not to be from the client, and we got a match to somebody else in the DNA database. So we're using DNA in a lot of these cases. But the important thing to remember is that the same problems that cause wrongful convictions in serious cases like rape and murder can also cause them in more minor cases. So an eyewitness can make a mistake in a rape case or a murder case. They can absolutely make a mistake in a convenience store robbery or when somebody grabs a purse and runs, especially when they're seeing mugshots. You know, the procedures that are used are just as vulnerable. So the lessons that we learn from these serious cases are ones that translate all the way down the pipeline.
Well, that was an issue, misidentification in a case of possible sexual assault that came up in the Kavanaugh confirmation hearings. Jeffrey Toobin said, I've never been sexually assaulted, but if I were, I'd remember who did it. But do you find that there are people who are sexually assaulted who made a misidentification of someone with whom they were at very close quarters?
So absolutely at close quarters. I think the difference between what people were talking about in the Kavanaugh hearings and what typically happens in our cases is the difference between your ability to identify someone that you know very well, and especially with whom you've interacted, say, at a party or in a social setting or in school for some period of time, that is much less vulnerable to misidentification, far less than a stranger. There's a lot that's been studied on it. We have a lot of information on our website about it. A lot of courts have started to write about this when they've been supervising the process through which identifications come in. But the very short and simple explanation is that memory is malleable like anything else. It's prone to great error. Our brains encode information in ways that we're just really starting to understand. But when you are the victim of a traumatic experience, your ability to accurately recall the details of someone's face and identify them later can get compromised through no fault of your own, unconscious processes. If you're the victim of a robbery and someone's pointing a gun at your face, there's a phenomenon called weapons focus, where you are looking at the gun, understandably, because you are terrified it's going to go off, and that is going to be the moment when your life might end. You're the victim of a rape, your mind is going through all kinds of horrible things. You may think that you could never, ever in a million years forget or mistake the face of the person who did this to you because it's seared into your memory, seared in there. But what is seared in may be inaccurate.
You had a case like that, didn't
yeah,
you?
we've had many of them. You know, eyewitness
Didn't you
misidentification.
have one where the victim identified someone and then turned out it was a misidentification?
We've had more than one. We've had literally dozens. It is actually, eyewitness misidentification is the single leading documented cause of wrongful conviction in DNA cases so far. There's a wonderful woman who's a friend of mine named Jennifer Thompson, who herself was a survivor of a brutal rape, misidentified the person who raped her when she was a college student, only found out 10 years later she had identified the wrong person thanks to DNA, and actually missed the identification of the correct person. She had seen him at some other point and said, I'd never seen that man in my life. And she and the exonerated person, Ronald Cotton, who did all this time as a result of her mistaken ID, wrote a book together about their experience. She's become a real champion for reform of the system and identification procedures.
They became friends afterwards.
They became great friends. And you know, what we have seen is that this is not a victims versus defendants issue, or a prosecutors versus defense lawyers, or a conservative liberal issue. You know, nobody wants to see an innocent person in prison. And it's a public safety issue, because when an innocent person is wrongly convicted of a crime, very often the person who actually committed the crime, by definition, will escape justice, but sometimes is a threat to others.
But you've had cases of prosecutorial misconduct, haven't you?
We
where
have.
They're either deliberate or inadvertent, where exculpatory evidence or helpful evidence was withheld from the defense?
Yes, we've had a number of them, of all kinds. We've had kinds where prosecutors were not made aware of information that was in the police files. Those aren't prosecutorial misconduct cases. Sometimes there is negligence in getting all of the evidence that you need to turn over. We've also had a number of cases, a troubling number, where there is what we think is very powerful evidence of deliberate misconduct. Prosecutors who have information in their own files that they know about, that they discuss with their colleagues, that they make a decision not to turn over to the defense.
Well, let's talk about one of those in a moment, but you find usually prosecutorial misconduct in high-profile cases, don't you, where there's great public pressure to...
You know, we discover it in those cases, but it's hard to know. I mean, by definition, it is hidden, right? Especially when you're talking about suppressing exculpatory evidence. If somebody shreds a document, buries it, doesn't put it in the file, a witness tells them, I don't really remember this the way I told the police, or I framed the guy because I was mad at him for taking, you know, my stuff or stealing my girlfriend or whatever it is, and they don't disclose the information, oftentimes I will never find out about it. The lawyers will never find out about it. In high-profile cases, we get more attention to it when we clear the person. And I think anecdotally we have seen, you know, at least some prosecutors who by all accounts are good people, who are not serial cheaters or liars, who are under enormous pressure to win the big case.
Pressure to win.
Yeah.
Now, there are many cases, aren't there, where prosecutors may misstate the evidence, where they do not disclose evidence that their Brady obligations require them to disclose. And then it takes you a long time doesn't it?
Long time.
Long tail.
Way too long.
Before you can achieve
Yeah.
an exoneration.
Yeah, yeah.
Typically.
Yeah, once,
Now, what
once
can
somebody's
be-
convicted, the balance really shifts. So before trial, you're innocent until proven guilty. As soon as you are found guilty, the burden is on you to get back into court and get the evidence to clear you, and it can be an enormous hurdle.
Well, let's talk about some of those cases. Lawyers always like to talk about the cases they won, and each of these cases involved a long time that an innocent person was in prison. Tell us about the case of Michael Morton, the Texas case.
So Michael Morton was one of our most extraordinary cases. They're all extraordinary in their own way. I mean, every single one is a tragedy and in some sense a wonder that the person persisted and got freed. Michael's case was a tragedy on many levels because he was a client of mine who was wrongly convicted of killing his own wife. His wife was murdered by a serial assailant.
Now, by the way, he was a white college-educated defendant.
He was a white college-educated defendant. Not the only one we've had, but certainly it's
Do you
in the
find
minority.
most of your clients are men of color who are not so well educated?
We have a mix of clients. Really, wrongful convictions can touch anyone at any time. We've had clients who were very well educated and had some money, but by and large, our clients are low income. We have seen disproportionate representation among people of color in the pool of exonerees, meaning their numbers are greater. African American and Latino defendants represent a greater share of exonerees, not just than their representation in the population as a whole, but even among the prison population. So even if you assume that some percentage of people in prison are guilty of the crimes, or that African Americans are targeted and prosecuted for crime at a disproportionate rate, we are seeing African Americans and Latinos exonerated at a greater rate than whites and to some extent Asians. Although that's
Okay, so back to Michael Morton. What happened to him?
So Michael's case got a lot of attention in part because he was white and college educated, and in part because of the human tragedy that it represented on many levels. The first level is that he was wrongly convicted and spent a quarter century in prison for a crime he didn't commit. During that time, his 3-year-old son, his only child, went into the custody of his wife's relatives who believed that Michael was the killer.
This is a Texas case.
It's a Texas case. He was a suburban dad and father managing a supermarket, living the American dream, picket fence around the house, literally. His wife was also working in an insurance company. They had a good, happy, fun, equal marriage. Had one child who had been very sick when he was little. He was finally, had a heart condition, finally getting better. And one morning tragedy strikes. Michael goes to work very early and his wife is murdered, literally bludgeoned to death by an assailant in their bed. And his son was seen by a neighbor wandering around in the yard and taken in by the neighbor, goes inside, and they discover the body.
Now, Michael served 25 years in prison.
25 years and lost custody of his child. His child was raised being told, your dad killed your mom. So Michael and his parents and a few friends were the only ones who stood by him and believed he was innocent. But the other person who believed him was his trial lawyer, Bill Allison, who called us and said, this is the case that keeps me up at night. I've never been able to forget it. Can you take a look? We were able to clear Michael through something of a small miracle. His wife's killer dropped a bloody bandana, a bandana stained with the victim's blood, literally evil Cinderella style, on his way down the block back to his vehicle. And through sheer luck and happenstance and what can only be called a miracle, Michael's brother-in-law, when walking around the neighborhood looking for clues, found something that the police didn't pick up, which was this bandana. Nobody tested it with DNA at the time. DNA in that advanced form wasn't available. And 20 plus years later, it was still sitting on a shelf in the sheriff's department.
How long does DNA last?
It can last for decades. And advanced technology is really good at getting tiny amounts of material. We couldn't get that bandana tested for 5 years. We were in court over the DA's objection. They said, like many of our clients, they said, he's guilty, this is a waste of time, this is a prisoner abusing the system, it's not going to show anything. They were afraid of the truth. Finally, we got an appeals court to order the testing, and when we got it, we hit a home run. It not only cleared Michael, it showed Christine's blood on the bandana, another man's DNA on the other side, but when we ran it in what's called the National DNA Database, CODIS, we got a hit to a man who it turned out had committed another murder of another young wife and mother in the county next door. We were able to solve 2 crimes at once. That murder had also been unsolved. So the tragedy was not just Michael's wrongful conviction, he was also a murder victim's family member, and because of the botched investigation in Michael's case, 2 years after he went to prison, another family lost their spouse, their mother. The other reason that Michael's case got so much attention, which you alluded to, was what we discovered around the same time that we found this DNA evidence, which is that the prosecutor had hidden in his files a wealth of exculpatory evidence. This included a taped interview with the victim's mother, Michael's son's grandmother, who had recorded in notes in great detail what young Eric, the child, had told her the day after the funeral of her daughter about the monster who killed mommy, and very clearly described the scene in a way that only a child who had witnessed it would have known, the weapon, how the body was left, and said Daddy wasn't there, and described a big man with a big mustache, which Michael didn't have.
Wow.
So that was hidden all those years, and the child was traumatized, suppressed the memory, clammed up, didn't speak of it again. But there was that, and there was other evidence in the file that pointed to Michael's innocence. And so we discovered this all at once.
And what happens to a prosecutor who pursues a case like this and has exculpatory evidence in the file and doesn't disclose it?
Typically nothing, although in Michael's case something did happen. So in a very rare move, in fact, the only time this has ever happened in any of our cases or our colleagues' cases, the former prosecutor, Ken Anderson, who would then become a judge, not only lost his law license, which happens occasionally, but actually went to jail. He pled guilty to contempt of court for concealing this evidence. He only went to jail for 4 days, but it was quite symbolic. I mean, his photo in an orange jumpsuit was on the front page of the Austin American-Statesman, the big newspaper in the region, and it sent a real message to prosecutors throughout the state that if you break the law, there will be personal consequences as well as professional ones. The other big thing that came out of it is that Texas took admirable strides to prevent what happened to Michael from happening again. So they changed the rules about what's called discovery, defendants' right to see evidence in the state's file.
And that was called the Michael Morton Act.
It's called the Michael Morton Act.
Okay, so let's just move on to another client. Are you in favor of capital punishment?
I am personally opposed to the death penalty. I actually got my start in criminal justice representing death row inmates. Before I was a lawyer, I was an investigator working for lawyers as a young college graduate.
So would you be against the death penalty, for example, for the synagogue shooter in Pittsburgh, a mass murderer? Or
I would. I mean, I am someone that is, the Innocence Project does not take a position on the morality of the death penalty. We do believe, and we have a lot of evidence, that as currently administrated, the death penalty gets it wrong far too much of the time.
Justice Breyer was concerned, and so was Justice Ginsburg, that there are innocent people on death row who may be even executed.
Yes, yes. And Justice Breyer wrote an amazing opinion in a case called Glossip. It was a dissenting opinion in which he talked about racial disparities in administration of the death penalty, geographic disparities. The most gruesome crime imaginable in one county might get a life sentence, whereas and no homicide is run of the mill because they're always tragedies, but sort of your typical robbery gone wrong, even a killing that is arguably not premeditated, which can get the death penalty depending on the accident of where you're prosecuted.
So let's talk about the case of Clemente Aguirre, who was on death row when you took up his defense.
Yes, our most recent exoneration, which was just 3 weeks ago, not even, 2.5.
How long was he on death row?
Clemente was on death row for 10 years and in prison or jail for 14 all told. This was a case that the Innocence Project assisted with. We don't take death penalty cases on our own because they're so complicated, but a lot of times people who I know in the death penalty community will call me for advice or assistance when they have a DNA issue, an issue related to prosecutorial misconduct. And we got the call in 2011, 2010 to see if we could assist with Clemente's defense. And we worked on that case in tandem with a lot of other lawyers and were able to not only get his conviction and death sentence in a double murder case reversed based on DNA evidence and evidence that another person, the one whose DNA was at the scene, had confessed to the murders to 5 different people. And still, the prosecutors in that case did not want to even get him off death row. They thought he should be executed despite that evidence. Clemente was a Honduran immigrant. He came here fleeing the drug gangs in Honduras that people hear so much about. He had no criminal record. He was literally a choir boy, won a singing competition in Honduras when he was young. And in one of those horrible, horrible twists of fate, found himself living next door to 2 murder victims and wrongly convicted of the murder.
So I know you don't get involved with this directly, but are any of these clients of yours who are exonerated able to get compensation from the state for the time they've wrongfully spent in prison?
So some of them are. We at the Innocence Project do a lot of work to reform the laws around compensation, and people who are interested in getting involved can go to our website and sign up for alerts in their area, petitions, things they can do. But not all states provide compensation, and some provide it under very restrictive conditions. They'll cap the amount at $10,000 a year for every year you're in prison. I don't know about you, but you couldn't even pay me $10,000 a year to sweep the subways, right? Or much less a day in prison. I wouldn't do a week for 10 grand.
Okay, so I have a question for you, Nina Morrison.
Yes.
This has really been wonderful.
Yes.
Do you have an estimate or a guesstimate as to how many innocent human beings are incarcerated in our prison system as we speak?
I don't. I mean, it is. We know that the people we've exonerated are the tip of the iceberg. We know that the justice system gets it wrong far too much for any of us to sleep at night, at least regularly sleep at night. I sleep sometimes. But if you assume that in a prison population, which is currently over 2 million, that 1% of the people are innocent, which I think is a vast underestimate given what we know about the system's flaws. That's 20,000 people.
So
if it's 5%, it's 100,000.
No shortage of clients for
No
you.
shortage of clients. We actually have a whole staff that is dedicated just to reviewing and evaluating requests for legal assistance. So the amount of work it takes to get just to the top of our pyramid where they get a lawyer is enormous. And we're very grateful and lucky that we're able to do the work.
Nina Morrison, you're doing God's work.
Thank
you so much for coming by. Great to talk with you always. And thank you for coming by. Tune in next week for more conversations. I'm Jim Zirin. Take care and all the best.